provision. So what the city attorney's office would be called upon to do is to render an opinion as to whether or not the petition that has been filed seems to invoke those particular provisions of the charter. And then we would render that decision. And if it does, then the city council would vote to place the other question on the ballot at the same time, should that petition get enough signatures to qualify for being placed on the ballot, and should the city council, determine to do so.
Madam Chair.
Yes.
So the way I understand this is sections A and B, and Laura, please correct me or John if I'm not understanding the language appropriately, but sections A and B provide explicit limitations on what can be placed on the ballot, which is a change from where we are today.
Right.
Okay. I think
Yes.
where our conversation was getting a little, I think, confused was, what's the remedy if someone, after sections A and B were to pass, want to come back and say, no, we want to change that so we can put a monopoly in place and we can do one of these things that are expressly prohibited in A and B. And as I understand it, the remedy for that would be, instead of, and again, please correct me if I'm wrong, instead of in one ballot measure changing the current charter language and imposing this new thing, we're saying, no, we have to have two votes, one to expressly change the charter and then one to expressly pass this new thing that you want to do that would be in violation of the charter. So
That's
my
correct.
point in sort of reiterating that is, the language, as I read it, does provide some explicit restrictions on what can be placed on the ballot in pretty clear language. And if I'm also remembering our conversation correctly, consistent with how the state tries to limit monopolistic interests from, utilizing government to enrich themselves. So there are some pretty explicit restrictions in here in terms of, what the city faced from previous measures. But it also provides a remedy in a way that I think makes sense to me, that if the voters did decide, yes, we want to change our mind on that, and yes, we want to proceed with this other thing, they have to do it in two votes instead of one. That's how I understand it, at least.
Yes, that's correct.
Laura, too, if you wouldn't mind, maybe just discuss a little bit why, instead of mirroring it as they did at the state, why wouldn't we just include a prohibition on self-dealing monopolies without creating a mechanism for two votes on it?
So that would certainly be a lot simpler. I definitely agree with that. Unfortunately, the provisions of the Ohio Constitution that I was discussing relating to the the inherent authority of the people to be able to petition and to bring that before their government would seem pretty strongly to conflict with a charter provision that would simply deny them the ability to do so. And so ultimately the question would be, if somebody, let's say we didn't do this second part, let's just say we just enacted 4216 A and B and said, you can't do this. Then the second question would come, okay, who would determine, once again, that a particular petition was in violation of A or B? Because of the structure of city government, that probably would come to the office of the city attorney and would say, okay, that's it. It violates substantively. Now we get an appeal then from the city attorney's decision or probably, a writ, not an appeal. We'll get a writ being filed against the actions of the city attorney, likely at the Ohio Supreme Court. And the case law that exists at the Ohio Supreme Court right now makes it very clear that cities don't have the authority to make a substantive determination as to whether or not a particular petition is legal or not legal. What we have the authority to do is determine whether or not the petitioners have followed the rules in filing a petition. And so in having our conversations about how to deal with this particular issue and how to craft provisions of our charter to protect the city and to protect public funds, we had to be cognizant of the fact that substantive prohibitions are going to be disfavored at the Ohio Supreme Court level, and that individual people are protected under the Ohio Constitution with the authority to be able to petition. So when you take those two concerns, which we talked about at the very beginning of charter review, and we talked about history of charters, when you take those two concerns, what is left to the city? And what is left to the city is the ability to at least, at the very least, to declare in our charter, we don't want to do this. And two, if you as the people are going to petition to do this, then we're going to make sure that the electors who are deciding that are going to be very aware of the fact that they are affirmatively making that change.
Okay, so here's what I'm going to suggest. We have original language, we have new language, and we need to understand what the difference is over here, because that is what the public is going to want to know. What does this allow us to do? What is the remedy? What is this over here, and why? So if, John, as we move forward, and let's say we approve this recommendation, we're going to need to do that type of detail, but in very plain language, in almost a, I would say, a chart. And maybe that's something that's within the recommendations for each and every one of the recommendations. Here's the original language, here's the minute language, here is what it did, and here's what it allows to happen now. Because I think that is going to be extremely important, particularly as you move forward and this information moves forward to the public for, number one, public comment, and then if we approve it, for recommendations to go to the ballot for individuals to be able to understand exactly what it is that they're voting for.
Yeah, absolutely, Chair Bartley, and I think that is the intent, especially as we get closer to a public comment hearing session, to have presentation and documents available that outline in pretty clear language what each of the topics that have been discussed already, even down to the simpler ones that may have the simplest explanation of why and how we're doing so, and have those available for folks. Yeah.
And I think it's going to be important for us to have that information as we move forward and decide to vote, to have that type of information so that we have detail and we have that fact-based information. So that should be, I think, a component in a document that we receive prior to moving forward on votes for recommendations to move forward on the issues. Because if we're going to have and I know this is a more complex conversation, but I think it's good to be consistent with each of the issues that we have and to talk about what it was, what it is, why the change, and what the outcome potentially is. Okay? Yes.
I'm sorry, I don't mean to beat a dead horse, but the article that appeared in the Dispatch, city charter changes would erode our rights. One of the concerns that the writer had was with section 43, as it had to do with the collection of signatures. And their contention was that during the collection of those signatures, they had to be from 5 of the 9 new city council districts, equal to 2.5% of the votes cast in the last mayoral election, or for a charter amendment, similarly require 5%. And the way that signatures are collected now would definitely be a change. Most of the signatures that are collected at large events. They're not, we're not asking people, what district are you in? I have to go to that district. I have to knock on that door. I have to make sure I get a certain number of votes from this district. And if not, then this amendment wouldn't be on. And the point about this was simply that that requirement would be onerous to the collection of signatures. So anyway, thank you.
I mean, I understand what they're saying. However, the voters decided, particularly with the redistricting, that that was how, because you don't want everything to just come from one area. So there has to be some criteria, and there has to be an at-large type of opportunity, as well as a districting opportunity, as far as being able to collect those names for those petitions. So I think what he is saying, that he probably doesn't want to have anything that criteria, that's how I read it. So, you know, kind of more of a free-for-all, and it's not saying it's been a free-for-all in the past, but it's a gentleman that I believe believes the rights of the people are being disenfranchised. And it was the will of the voters to move forward, particularly with the new ward system and the districts, and the way in which collecting petitions move forward as far as people being eligible to be on the ballot. So it's not anything that I think that, I mean, it could be a recommendation that comes to us from the public for consideration, but it is something that was already within a public forum and decision-making when it went with the whole ward component for city council.
Thank you.
Oh, you're welcome.
I'll make a quick addition to that, Madam Chair, which is, we have to strike the right balance between ballot access and making sure we have, an appropriate process for people to petition city government. We are not, and we discussed it briefly at the last meeting, but in this recommendation, we're not discussing increasing the overall threshold requirement number. So I think, my view is if we're going to keep the number the same, which varies a bit by type of initiated petition, 5% for ordinance, 5% for referendum, 10% for charter. We're not currently discussing whether or not we should increase those thresholds. But what this language says is that we'll keep that threshold the same, but we'll just make it consistent, so there has to be some signatures and some voice from the different districts that are going to be now in place. So that seems reasonable to me. That's just my opinion. But, I think it's all, a balance between, access and, making sure that, we're not flooding the ballot box
Right.
with, petitions after petitions. And, because that can be a challenge as well, in my opinion. Again.
Any other comments?
I have a question related to Section 43. Are there any other municipalities or political subdivisions, larger political subdivisions like Cleveland, so on and so forth, that use this type of rule related to collecting signatures that we know of? And that's to John or Laura, or anyone else that can.
John was the one that did the looking at other cities. I don't specifically recall looking for that particular question.
And I would have to go back and check, but I can give you an answer shortly on that. Not to my knowledge,
Okay.
when I looked at a few of the Ohio cities. Obviously, Ohio cities would be who we're dealing with on this, given the existing rules under the state constitution. But not that I saw, but I will dive in a little deeper on some of the maybe smaller Ohio cities to see if there are any examples of that, but not in the larger ones to my knowledge.
Certainly. Thank you.
Any other questions from the commission members?
I do have other questions
Okay.
related to another section. As it relates to the transparency, this is Section 42-17, the disclosure of requirements for certain initiative petitions. As it relates to the name and addresses, that need to be, outlined in the petition committee or for the petition committee. Is there any prohibition on the type of address? I don't know if Title 35 addresses that, but I'm assuming there cannot be any PO boxes associated with them signing or being listed with the name and address. I'm assuming that there has to be a physical address for the individual that is listed as a member. Is that correct?
That is my recollection. I'd have to go back and specifically take a look at Title 35. But just to be clear, the name and address of each member of the petition committee is something that we already require. So it's the other provisions that are in addition specifically for these types of petitions.
Okay, so that's our, okay, thank you.
Yeah.
Commissioner, do you have other questions you'd like to ask as well?
Not at this time. I wanted to come back to 43, but I'll make that comment later. I want to think about that a little bit further.
Okay.
Thank you.
Well, I guess I'm asking due to the fact if the other commission members feel comfortable moving forward as far as with the recommendations, and having a motion to accept those and to move forward with the recommendations for the initiative process.
Chair Bartley, I have a question. I thought we were going to ask somebody on staff to come up with pros and cons. How was it and how is it going to change? Did we do that? Or,
I guess I was asking for that after we pass the recommendation, so as we move forward,
okay,
when it goes to public comment and
Okay.
public hearings. However, you are correct, as we move forward with other issues that we're just beginning, that is the type of information I would like to see for each of the commissioners to receive, looking at what the current language is, what the new language is, what is the why of the change, and the explanation of what the new language will do.
thank you.
Thank you.
I would think that in lieu of being able to make another suggestion, that our only option is to either vote this for or against, but probably for, because, and I'll say this for me, I don't have another suggestion about an alternative for this. So I suppose that moving forward and voting for it would be our next course of action.
Okay, well, then I will put the motion forward. Do I have a motion to accept the recommendations and consider the charter review for the initiative process recommendations for the amendment to the city charter?
So move.
Do I have a second?
A second.
All in favor?
Aye.
Against, same sign?
Can I ask a question before we finalize this vote?
Yes.
So my only reservation really is, it just seems like this is relative to the previous motion that we accepted, a little bit more complicated. I mean, I would like to hear what the public has to say through these public hearings and get feedback on this before we move forward. Now, I understand, and maybe you'll correct me if I'm wrong, that we could also modify this before we send our final report to council. But I don't know that it serves a great purpose to approve something now only to change it later. Like, why wouldn't we put this on the table now, go through these public hearings, get some further input, and then come back at the end and make some final recommendations? I mean, I suppose we could sort of move this forward now with obviously the ability to change it later, but I don't know. It just feels like it makes sense to get some public feedback on this.
I agree that it's important to get public feedback, but I think we also need to go the public with with our recommendation and to hear back from them as far as if they are in agreement or if they have other solutions or options, which would require an amendment to the recommendation moving forward. But I would like to manage it in a way that we bring them something to react to and not something that's tabled. So therefore, we can have dialogue.
That makes sense. Okay, that makes sense. Thanks, Madam Chair.
And Madam Chair, if you don't mind, wanted to also add or ask, as far as the amendment process, what does that look like? Because again, I do have reservations, particularly with Section 43, and again, I'll reserve those concerns that I have with it, with still voting forward, but would also like the possibility of amending that particular language. But what does that amendment process look like? Is that something that we bring up as new business moving forward, and that's just for anything that we discuss?
Right.
What does that process look like?
I'm
as
going to
far as-
ask Laura and John to answer that.
Sure. So really just passing as a motion at this point. If since you did do that, there is the option to make a motion amending that to include different language later on. The only thing that would be binding out of this commission would be the final recommendation that are turned in at the end and that are owed to council by July the 10th. So, and there will be another opportunity and a vote to approve that entire document as listed. So, this vote now is a little more informal. The motion's more informal. It can be amended. The final report, however, when you cast your vote on that, that will be the vote that kind of enshrines it in the report that ends up going to council and the mayor.
And follow up, Madam Chair. And thank you for that, John. And so going off of that, it's my assumption that if we do, as members or as commissioners, want to introduce an amendment to one of these, items that we're reviewing, that we bring it up as new business. Is that correct? So when it's the time to bring up new business, is that when we discuss a possible amendment that we want to introduce for a specific topic that we're reviewing?
I mean, I think that's at the discretion of the commissioners and the chair, whether it would be considered new or old business. We can place it however folks would like.
That's a good question.
Just from a logistics standpoint.
I guess I think since we've discussed it and reviewed it and had public comment and make a recommendation, I believe that would make it new.
Okay.
business.
The amendment would be new because it categorizes new business. Okay. Okay. Yeah, thank you.
No, thank you.
Do we take, I'm sorry, Chair Bartley, do we take the vote? Because we haven't.
No, we took the vote, but what I would like to do is take the vote again.
Okay. Okay.
Do I have an emotion to approve the initiative process recommendations for the amendment of the city charter?
So move.
Do I have a second?
Second.
All in favor?
Aye.
Aye.
Against, same sign. Thank you, it passes. I think that was great conversation. Okay. And that's what we're here to do. Okay, new business, open meetings presentation. Laura? Laura?
Thank you. I just want to make sure I'm able to share my screen. I am. Okay. Hopefully this will be a little less confusing than the last one. This one is a little bit more straightforward. We've talked about it a couple different times during the charter review meetings about, we kept saying open meetings, oh, we'll talk about that later. Today is the day. So I wanted to talk a little bit about what the city charter currently does relating to open meetings, what the recommendation is for change and why that recommendation, and how this would comport with existing state law, just so there's a clear understanding of what the city does, what the state requires, and why we are recommending change. So what's in front of you right now is the current city charter provision. That's section 240. Open meetings. The general bodies of the city shall hold all meetings in accordance with the general laws of the state pertaining to open meetings. So what this means in this provision of the city charter, and there's another one that makes a similar reference, is that the city right now in its charter points specifically to state law for purposes of determining what constitutes an open meeting, how they are to be noticed, what constitutes being in person for an open meeting. Everything we follow state law. And that's actually worked out fairly well. State law has a pretty good, robust ordinance or a law that pretty much spells out what's required. And down below, the part that's going to be relevant to our discussion here today is that provision of state law. So this is from Revised Code 121.22C. All meetings of any public body are declared to be public meetings open to the public at all times. A member of a public body shall be present in person at a meeting open to the public to be considered present or to vote. So that's the current state law. As everybody is aware, we had some problems starting a couple years ago. So when COVID came and we immediately overnight had to pivot and determine how to hold and conduct governmental business without being in person, we created a problem for a number of municipalities, such as the city of Columbus, because a number of cities like Columbus pointed back to state law to determine what constituted an open meeting. And so it wasn't until the General Assembly then came along late March of 2020 and passed an emergency provision that we were then in the city of Columbus able to conduct city business with public bodies. Because prior to that, due to restrictions, of course, on 6-foot distancing and masking and generally being in public at all at that point in time, we couldn't conduct our business. So, excuse me. The General Assembly passed emergency legislation, House Bill 197, Section 12 of which dealt with open meetings. It was signed into law by Governor DeWine on March 27th, 2020. What it specifically allowed for was for members of a public body may hold and attend meetings and may conduct and attend hearings by means of teleconference, video conference, or any other similar electronic technology. It specifically then spelled out other expansions of the open meeting provisions to allow for teleconferencing and video conference to meetings. For instance, it specifically stated in section B2 that an individual shall be considered present as if in person at the meetings of a hearing and shall be permitted to vote if the meetings are conducted in accordance with the provisions of the emergency legislation regarding notice and regarding how those videos are supposed to be conducted with technology. Specifically, they made sure that the public would be able to attend, and that's very important. So these meetings were still open to the public. They were just taking advantage of the new technology to allow those meetings to be public in a different way, similar to how I'm coming across to you right now. Public bodies shall provide notification of meetings and hearings held under this section to the public. The public body shall provide the public access to a meeting held under this section. The public body shall ensure that the public can observe and hear the discussions and deliberations of all the members of the public body. And the public body must establish a means through the use of electronic equipment that is widely available to the general public to converse with witnesses. So in other words, we wanted to make sure that whatever communications we were having in an electronic forum, in a digital or virtual environment, mimicked as much as possible the existence of attending that meeting in person. The public would need to be able to speak, they would need to be able to hear their representatives converse, and they would need to be able to assure that it was both video and audio in real time. So we all adjusted, right? All of the meetings within the city of Columbus, we were able to get the technology necessary to move those meetings to a virtual format so that the business of government could continue during the pandemic. And what we discovered when we did that is that we actually had, let me go back a second. what we discovered is that we actually had, in some circumstances, more participation by members of the public than we had prior to when it was required that everybody attend in person. So we would have more individuals that would watch on YouTube or on Facebook as it was streaming and those various social media devices. We would have the ability of individuals to be able to present comments on some of the smaller boards and commissions that maybe individuals were certainly not aware or as aware were going on during that period of time. And we also found that once we adjusted and corrected some of the technological problems, that we were able to provide hearings in this virtual environment that were as robust and that allowed for the deliberation of the public bodies and public input. So the interesting thing about this is that as we've been talking about home rule throughout the entire time related to charter review, the provisions of the open meetings laws are provisions that deal with local government. And under the home rule provision, the city has the authority to legislate to adapt these changing technologies. Home rule gives municipalities sovereignty over matters of local government. And in such matters, if a provision of a municipal charter conflicts with state law, it's the charter provision that will prevail. So we have the authority to change the law, to change the language in our charter, so that going forward, should there be a desire or should there be a need to have particular bodies within local city government conduct their hearings or their meetings in a virtual environment, we wouldn't be dependent upon the General Assembly making that decision for Columbus. So right now, I'm here and conversing with you now because there is once again an emergency provision to the open meetings law that was enacted by the General Assembly that's continued, I think, till early June at this point. And so we're able to do this, but without amending our charter, the city is going to be beholden to decisions at the state level should we decide that it would be advantageous for government to be able to conduct itself in a public meeting in a virtual environment going forward. So the changes that are being recommended to the commission for your consideration would be changes that would allow the city to have that flexibility to make its own determinations as to when and how meetings will be conducted for the public and that the public can participate in. The recommended changes are to Section 240, which we looked at the beginning of this conversation. The public bodies of the city shall hold all meetings in public. So very much recommending that public stays in the charter, but instead of as being provided for under the general laws of the state, instead let's have it as provided for by ordinance of council. That would then give the ability of city council to enact laws that can deal with the very specific aspects of what it would mean to constitute an open meeting, which is what they do at the state level. I mean, just want to go back and clarify that when we were talking about the General Assembly enacting emergency legislation to allow for open meetings to occur in a virtual environment, it's really important to note that they were able to do that because their open meeting provisions are not in the state constitution. The open meeting provisions are in the Ohio Revised Code. So when an emergency came about like that, they were able to get together and make a decision and to enact legislation to allow for those emergency meetings. If the state constitution had in its state constitution a requirement for open meetings, we would have been in a very different situation. We would be in the situation that Columbus was before the General Assembly acted. Second recommendation is that there's a second provision. The provision of the charter, section 8, dealing with meetings of council, also uses the same language. It specifically points to the mayor, the president of the council, or any 3 members thereof may call a special or emergency meetings of the council as provided for by the general laws of the state. We would make the same recommendation that instead of the general laws of the state, it would be by ordinance of council. And same thing after that. All meetings of the council or committees thereof shall be held in public in accordance with the general laws of Ohio pertaining to the requirements for open meetings. We would instead recommend all meetings of the council or committees thereof shall be public meetings as provided for by ordinance of council. And just so that it's clear as we're talking about making sure that there's an understanding of what we mean by that, we have provided to you recommendations that we would then turn around and make to council, or that we would offer up to council to consider for what that would look like in court. Just so when you're weighing in on this question, you would have an understanding of what we contemplate that would look like. And this one, to answer a question that I guess I'm guessing would comment, this came from the city of, I believe, Cleveland, who also looked at this same issue during the time of the pandemic and adopted for their city government provisions pertaining to public meetings. This has been adapted to the city of Columbus, but it largely comes from that as a source. So we would then instead have a chapter 119 of the Columbus City Codes. It would go through, it would discuss what it means to be open to the public, what a public body is, what it means to be virtual. It would require that meetings be held in accordance with the general laws of the state unless otherwise provided for in this chapter or by ordinance of council. And then it would go on and determine what it would mean to be able to hold a virtual meeting. So to be clear, these recommendations that you've received and that are up on the board here now would not be proposed changes to the charter. These would be proposed city code that council could then enact in the event that the charter changes pass at the ballot. So that's the last one. We would also address notification and meeting minutes. This is also to deal with advancements in technology. Right now, we have the capacity and the ability to maintain full audio, video copies of meetings that are streamed. We're not required to retain them, but if we do retain them, we are able to keep them. And so this provision 11909 would talk about whether or not we would also need to prepare more substantive minutes when we've kept a copy of the video of the entire meeting. So that is the recommendation. I'm going to stop sharing my screen so I can answer any questions that you might have.
Are there any questions of the commission members of the presentation that you just were given by Laura?
I have a question, and I'm sorry, Laura, if I wasn't following along. Is this so this is for all public bodies or public city bodies to abide by? So it's not just city council?
That's correct.
It's all public bodies. Okay. Thank you.
Just a quick question, Laura. Do you envision, these virtual meetings being tied to any specific emergency? I mean, I understand we're essentially giving council the latitude to make that determination, but do you envision this as the use of a virtual meeting sort of for any reason or for any specific emergency related reasons?
So the recommendations that I'm making here are that we put that decision in the hands of the city council so that those decisions can be made not at a blanket stage, but on a case-by-case kind of basis. For instance, it might make sense that city council, because it is the elected body, it's the legislative body, it might make sense for city council to make a determination that we are going to meet in public, in person, unless there's an emergency. That might be the determination that they make. It might also be that some of the smaller boards and commissions that function throughout the city, where it's difficult to get individuals to participate and to be able to leave their jobs during the middle of the day to come down and have a hearing, it might be that some of those boards and commissions would make sense to always meet virtually. But the recommendation to this commission is to give the city the ability to make those decisions rather than tying us to the General Assembly as it is right now under our charter.
Any other questions?
May Chair Barley. Just to add to that a little bit, the ability for a city to do this is not unusual in the state. Just off of the top of my head here, with a few cities we looked at for charter and code of ordinance language and just given some of the events that had happened with COVID, Cleveland and Akron specifically leave a large portion of the public meetings law to their code, and had done this previous to COVID, so that they were able to more nimbly address the issue in the past couple of years. Cleveland specifically doing it, I believe, in June of last year, giving themselves the flexibility to go virtual, and they were able to do that without going to a vote of the people to change the charter. The second thing being that with this recommended change, should you all decide to recommend it in some form, would place the onus, or a good deal of the onus for organizing how the public meeting code would look on city council itself, because it would have to be passed via ordinance. So you would be putting a little bit of work on them. The changes you would look at would be just a few minor language changes in section 240. But it would then make it incumbent upon council to actually act on your recommendations. So you would be asking them to do that, and Laura and the city attorney's office and staff could organize recommendations. Those could change, but it would be placing an ask on council to do so.
Can I add to that, John? I don't mean to interrupt.
Sure.
I also wanted to make it clear to the commission that if this amendment were to go forward and were to be accepted, there is another provision of the city charter saying that if the city charter or codes don't specifically address an issue, then we will follow state law. So we would never be in a situation where we wouldn't have an open meeting provision. What this would do is it would take away the affirmative statement that we will follow state law only, and instead leave that decision to council. But if council, for whatever reason, didn't act, then with that other more general provision of the charter saying, hey, if our code is silent, then we follow state law, we would then have to follow state law in open meetings. So it would give us flexibility, but it wouldn't negate it. Just I want to make that clear.
Comments, questions by commission members?
I have a question, Madam Chair. During the pandemic, were these public bodies required to record their meetings, all virtual meetings?
They were not required to. Many of them did as a matter of course, but they were not specifically required to unless they had a provision in their bylaws that required them to do so. So for instance, some of the public bodies conduct due process type hearings. They're actually adjudicating a request, like a request for variance, what have you. Those bodies had already been in the habit of conducting those with video recording for those purposes. And so some of them were already maintaining them, but it was very much dependent upon the specific bylaws or requirements of the given body.
Thank you.
Any other questions? Well, just to follow our process, what I would like to do is to take this information, give ourselves the time frame to really review it, see if we have any questions after we have reviewed, bring it back for old business next time before we decide if we want to move forward with a recommendation. Okay. Laura, thank you for your presentation. Much appreciated.
Happy to be here.
Administrative items, John.
Sure. Thank you, Chair Bartley, Commissioners. Just two things real quick. One was to make you aware of a public comment that was received by us for the recommendation for the commission. It was a process recommendation that we that we post the agenda for the upcoming meetings a bit earlier than we were. So maybe not even when they're completely finalized. But we took that recommendation. The draft agenda for this was posted a few days ago in tentative format. So we would accept that recommendation if it's fine with commissioners to just go ahead and post our agenda a couple days earlier and for public consumption. That was the only comment we had received thus far. So we'll go with that. And the other is just to thank you all for responding on scheduling for the hearing for public comment for the commission coming up. The date agreed upon was May the 10th. That is Tuesday, the second Tuesday of next month. It will be here in council chambers from 5 to 7 p.m.
Okay.
And that is all I had. Thank you.
Okay, thank you, John. Any other questions from commission members prior to us adjourning?
Madam Chair, got one
Yes.
more question. John, this is related to the agenda inquiry. If you post the agenda earlier and it happens to be amended, will there be a notification sent out, or will it just be amended and folks will have to check back? Is there a process associated with that? Or will you develop a process?
So my intent would just be to make sure that if there is an amended agenda or something significantly changes to update that on the website and indicate that it has been updated on the website.
Thank you.
Thank you.
Thank you. Other questions, comments? Okay, hearing none. Again, commission members, thank you for your time today. And could I have a motion for adjournment?
So moved.
Could I have a second?
A second.
All in favor?
Aye.
The meeting is adjourned. Thank you.